All right. Thank you so much for being here tonight. I'd like to give you a brief introduction to PMC as well as our speaker, and then we'll get started on our presentation. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, accessibility, and respect. For over 35 years, PMC has worked to educate all Pennsylvanians about the courts and how to navigate them with confidence. While we are not offering legal advice today, we hope this presentation is informative and educational to you all. On behalf of PMC, thank you so much for joining us tonight, and thank you to the Carnegie Public Library for hosting us and the Allegheny County Law Library for partnering with us. After the event is over, you'll be receiving a recording of this program as well as a questionnaire. Filling out the questionnaire helps us bring you more workshops like this one. Our speaker tonight, Judge Nicholas Martini, has previously worked as a public school teacher, as a supervisor of the City of Pittsburgh's Federal Community Block Grants Program, and as a municipal manager for Stowe Township. He is an Allegheny County native and the son of a judge himself, and he was elected to his judgeship in 2021. And at this point, I'll turn it over to you, Judge Martini.
Thank you so much, Nina, for the introduction. So I'm happy to be able to join you tonight to present this Protection from Abuse workshop for Pennsylvanians for Modern Courts. I've been hosting these workshops every year since I've been in office. So I've spoken on a few different ones, including protection from abuse orders before, landlord-tenant matters, civil complaints, and that process as well. And then also an overview of our magisterial courts. I was on a panel 2 Octobers ago, so which was also very informative and well attended. So I'm happy to be able to do this presentation tonight. All right, so as we get into the protection from abuse orders. So a simple question, what is a PFA, which is the shortened version of protection from abuse order? So a PFA is a civil court order to help protect victims of domestic violence, providing relief from abuse by an intimate partner, family, or household member. You must meet one of those criteria in the state of Pennsylvania in order to get a protection from abuse order. If you do not meet those 3 criteria, once again, be a current or former intimate partner, a family member, or a household member, or obtaining a protection from abuse order on behalf of a minor child, you will not qualify for a protection from abuse order in the Commonwealth of Pennsylvania. Here's some statistical data of protections from abuse cases that were filed in the past decade, 2014 through 2023. You can see there was a little dip kind of during the COVID period, but the orders have certainly spiked up in 21, 2, and 23. 2024 data apparently is not yet available, but I would assume the trend has probably stayed in the uptick. So since I've been in office, which has been from 2022 onward, I have actually issued, as of through today, I have issued 317 emergency protection from abuse orders in less than 4 years. So it just goes to show you the volume. And there you go. The volume in Allegheny County. So, I mean, as you can kind of see there, through 2023, we're issuing well over 4,000 per year. So, I mean, and they said I've done 317 emergency ones myself in a 4-year period. And there are also 46 magisterial district judges in Allegheny County, as well as 43 common pleas judges. Frequently asked questions. So, yeah, also obviously, to get more information for particular questions you may have, Neighborhood Legal Services has a website, as long as Allegheny County Courts Family Frequently Asked Questions. So these could be for more detailed questions you might have, or if you just don't want to talk about it, in a public forum or in a recorded setting, you certainly can use any of these websites to get more information on a private basis for yourself or for someone else. So what is abuse? Causing, trying to cause, or threatening to cause physical harm, rape, or sexual assault, putting someone in reasonable fear of immediate and serious harm, stalking or performing acts that would put someone in fear or harm, kidnapping or extreme control. These are all examples of what would constitute abuse if someone needs to get a protection from abuse order. They can also be, though, I mean, it could be other levels of abuse too, emotional, not necessarily physical, but could be emotional abuse, psychological abuse, financial abuse. Someone's, taking all of the couple's money for themselves, leaving, the other partner in distress and distraught. I've issued some emergency protection abuse orders based on that kind of abuse, even though it wasn't physical, it was basically financial exploitation of the partner. Who may file for a PFA? We did go over this a little bit, but a victim of abuse may file for a PFA order against an intimate partner or a family member. This includes spouses or ex-spouses, current or former sexual or intimate partners, including dating relationships, family members related by blood or by marriage, including parents, children, siblings. So any family member would be able to get one against another family member. And the same, just to go a little deeper into current or former sexual or intimate partners, including dating relationships. Obviously, this does not have to be between a married couple. It certainly can be between people who were dating or currently dating, or just, it could be they could also just be issued for someone who was not necessarily in a dating relationship, but was an intimate partner at some point against someone who is causing them either, physical or psychological harm. What types of relief may I seek? Stop abuse, threats, harassment, or stalking, eviction or exclusion of alleged abuser from a residence, limitations on child custody or visitation rights, turn weapons over to police or sheriff, pay spousal, child support, or health insurance, no contact, harassment of victims of abuse, including extended family members, pay reasonable economic losses due to the abuse. One item I'll touch on a little bit. So, I mean, some of this is obviously self-explanatory, but the bullet point 2 on the left side, eviction or exclusion of alleged abuser from residence. So to do an eviction regarding a protection abuse order, the plaintiff, who is the one seeking the abuse relief, needs to prove that they either own the home or are on a lease. We cannot evict a alleged abuser from a residence that they own solely or they are solely on a residential lease. So you, the plaintiff, have to be on one of those, either a co-owner of the house or a co-leasee. So if you're living with someone who it's their lease, you're the one that has to leave. We cannot do an eviction from someone who is a leaseholder or property owner if you're not a party to that as well. If that makes sense. I could expand on that if anybody has questions later, but we'll oftentimes have to ask somebody, who do you own the house? Do you rent it? Are you on the lease? Are you on the deed with this person? So you can't, we can't evict them from their residence that they solely own or lease, as long as that's understandable. Emergency or temporary PFAs, both are free to file. How do I get protection during normal business hours? If the abuse occurs during the week, you may file for a temporary PFA order at the Allegheny County Family and Juvenile Court Facility, which is located at 440 Ross Street, Suite 3030, Pittsburgh, PA 15219. Phone numbers listed. This is our family division. So Monday through Friday, if you arrive anytime between 8:30 and 11 a.m., expect to stay at PFA court for 3 to 4 hours. So as long as you arrive during that time period, you will see a common pleas family division judge who has the authority to issue a temporary protection from abuse order, which is good for 10 days. You will need to complete a PFA petition and appear at the hearing before a common pleas judge, as I just said. A free, secure children's playroom is available at the PFA court. So you can bring your kids down if you need to. If someone watching them is an issue, you can certainly bring them down. There is a child care facility on site. How do I get protected? An abused person can go to their local magisterial district judge's office anytime after 11 a.m. during regular business hours, Monday through Friday. But call first to verify that the district judge would be available if they're in the office, or if they are having hearings, they might not be readily available to do it for you. You can also at any time, as long as it's after 11 a.m. on a normal business day, and as well on a weekend or court holidays or after business hours, you may get an emergency PFA order from any magisterial district judge that would be working at our Pittsburgh Municipal Courts building, which is a central court located also downtown Pittsburgh, 660 First Avenue, Pittsburgh 15219. District judges have the authority to issue emergency protection from abuse orders that will last until the close of the next business day. You should then file a temporary PFA order, which you still have to do with the Court of Common Pleas Family Division the next business day. So, for example, if I'm working at Pittsburgh Municipal Court Friday at 4 p.m., and you come in to get a protection from abuse order, your emergency protection from abuse order, if I grant it, is good until Monday at 5 p.m. However, if you do not go to Family Division Monday morning between 8:30 and 11 to try to extend the emergency protection from abuse order to a temporary, that order will expire Monday at 5 o'clock, and there will be no more protection in place per that order. Also, as of January 2025, animals can now be included in an emergency PFA or a temporary PFA application. This is a new law change that took effect in the middle of January. So, if you have a pet, you have a cat, you have a dog, any kind of animal, if you do not want your spouse, partner, for the animal to stay there, you have to include them, and they can be awarded to you during the temporary and emergency PFA process. How long does the temporary PFA remain in effect? I kind of went over this a little bit, but the temporary order will only last until the date for a final hearing set by the PFA court, where both sides may present evidence to a judge. In order to extend the temporary PFA, you must show up at the courts for the final PFA hearing. The final hearing will take place within 10 business days of the issuance of the emergency order. So there's basically 3 PFAs in effect here. If you go see a magisterial district judge after business hours or anytime after 11 a.m. on a weekday, you're going to get an emergency PFA, which is only good until the next business day, the close of it. So you have to then get a temporary PFA from the Court of Common Pleas Family Division, which is good for 10 days. Then, as we mentioned here, a final PFA determination hearing will be set. It's not an ex parte hearing at that point. Both parties have the right to be present and present their cases and evidence to the Common Pleas judge. If the judge determines that abuse is occurring, they will order a final PFA order, which I think we're going to get more into. What do I do with a PFA order? You will be given 3 copies of an emergency PFA order. Keep one with you at all times. Give 1 copy to your local police department and give 1 copy to the police department where the abuser lives. Here's some domestic violence programs and hotlines. Also, you can call the Ali Kiski Hope Center, Crisis Center North, Women's Center and Shelter of Pittsburgh, and the Center for Victims. Their websites and phone numbers are obviously available to you. Legal representation for a PFA hearing. The PFA court strongly recommends that plaintiffs obtain legal representation for the final hearing. So, just reiterating, an emergency PFA hearing and a temporary PFA hearing are ex parte, meaning it's just you, the plaintiff, telling the district judge or the common pleas judge about the abuse that you're claiming. However, at the final PFA hearing, that's not an ex parte hearing, so the defendant has the right to be there and does have the right to legal counsel. So it is definitely encouraged that you also obtain legal representation for a final PFA hearing. You can apply for, free legal representation. When applying for a temporary PFA order, plaintiffs may complete a lawyer referral application. They may meet with a legal advocate to determine if they qualify for free representation for the final hearing. Neighborhood Legal Services, their phone number and address, that's also an option. And obviously, you'd have the right to private legal representation as well. Plaintiffs may retain their own private or divorce attorney to represent them for the final hearing. And you could call the Allegheny County Lawyer Referral Service if you're searching for an attorney who does that kind of practice and work. How is the abuser notified of the protection order? Both the emergency and temporary orders are issued without the abuser present. A victim of abuse who files for a PFA is known as the plaintiff. It is the plaintiff's responsibility to transport a copy of the temporary order to the police for service. The police department where the alleged abuser lives or works will then serve him or her with a copy of the temporary order. The alleged abuser is known as the defendant. A second option is where someone over the age of 18 may personally serve a copy to the defendant. The person serving the notice signs an affidavit of service afterward. This affidavit of service must be brought for the final hearing. So in order for any PFA, whether it be emergency, temporary, or final, more so though for the first two, the emergency and the temporary, service has to occur for the protection of abuse order to then be in effect. Meaning that the defendant must know that there is an abuse order out against them before they're required to stop their behavior. What should I expect at the final hearing? The final PFA hearing is the scheduled date and time for the defendant to appear in PFA court to either contest or consent to the issuance of a final PFA order. Dismissals. If the plaintiff does not appear at the final PFA hearing, the temporary PFA order may be dismissed. So if you're the plaintiff and you go all the way, you get an emergency, you get a temporary, and then you do not show up at your final hearing, it's likely going to be dismissed. The plaintiff is required to appear. Withdraws. The plaintiff may withdraw the request for a PFA and the temporary PFA order will be terminated. If you, the plaintiff, decide that you no longer wish to seek the final PFA order, you can withdraw it at the hearing. What should I expect at the final hearing? Also, continuances. A temporary PFA order may be extended and a new final PFA hearing date may be rescheduled for various reasons. Continuances may be granted when the police have been unable to locate and serve the defendant. Defendant requests more time to obtain legal counsel, or either party or their attorneys make a reasonable request for a continuance. So your temporary order, though, would be extended. So you would still have the protection, but the final hearing can be continued based on some of those reasons that we mentioned, and it would be up to the common pleas judge if they're going to grant a continuance. Final PFA order by default. If the defendant does not appear at the final PFA hearing and there is sufficient proof that the defendant received proper notice of the date and time of the hearing, then a final PFA order may be issued against the defendant for up to 3 years. Final PFA order by consent. If the defendant appears at the final PFA hearing, the parties are given the opportunity to negotiate a settlement of the case through the entry of a final PFA order, which could also, once again, be up to 3 years. Both parties must agree and give written consent to the length and terms contained in the final PFA order. What should I expect at the final hearing? Continued. Final PFA order after a hearing. If the parties cannot negotiate a settlement of the case, a final PFA hearing will be conducted by a judge. Both parties may testify and present relevant witnesses, testimony, and evidence about the case to the judge. The judge will decide if a final PFA order is issued, and if so, for how long. How long can a PFA order last? Emergency orders only last for the weekend they are issued. Temporary orders last up to 10 days within which the time the judge schedules the final hearing. Final orders can last anywhere from 1 day to 3 years. A judge can extend any of these orders if they feel you are still at risk or if the defendant violates the order. What happens if a defendant violates the PFA order? There are two different types of provisions within a PFA order. Typically, a final PFA document can be anywhere from 5 to 10 pages, depending on if there's children involved, if there's a lot of different special circumstances regarding any kind of contact that may or may not occur regarding custody of the children, etc. So there's a lot of provisions. There can be a lot of provisions in these orders. So it's important that you, the plaintiff, and the defendant read through these documents, understanding what and how you can and can't not do things depending on this order, what kind of contact you may be able to have, if any. So it's important that both of you understand what this order, if it gets to a final order, says. So as I kind of reiterate, as I kind of mentioned, but PFA order is composed of many sentences and sections. Some of these sections or provisions guarantee the safety of the plaintiff and other abused persons. These provisions include no abuse, exclusion from property, custody, no contact, no harassment, stay away from work, school, giving up weapons. These are all safety provisions. A second type of provision does not involve physical safety. These non-safety provisions discuss support, damage, attorney fee payments, and orders for defendants to go to batterers counseling. What happens if the defendant violates the PFA? The plaintiff should immediately call 911 and request police support. Local law enforcement may be able to arrest the defendant for violating the PFA order. If the police do not arrest the defendant immediately, you must take a copy of your PFA order to either your local MDJ's office or to the arraignment court in the Pittsburgh Municipal Courts building. You can file an indirect criminal contempt complaint for violation of a protection from abuse order, which is called ICC, with your local magisterial district judge office or at the Pittsburgh Municipal Courts building. But you must take your PFA order with you. We need that proof that there is a PFA order in effect with the dates that it's in effect for, and the terms and conditions, which is something that the magisterial district judge has to look at when you're telling them about your ICC alleged violation. An arrest warrant may then be issued for the defendant and they will be arrested. So if you come in, you're claiming that the defendant, you have a temporary emergency or a final PFA order, and you're claiming the defendant has somehow violated this order, you need to have the order and you need to tell and show the magisterial district judge how the defendant has violated the order, whether they're texting you, whether they're calling you, anything, whether they've seen you someplace and there's some kind of abuse. So that needs to be that you would write all of that in the ICC complaint. And then we would issue, if the judge finds sufficient evidence, they'll issue the arrest warrant for the defendant. What happens if the defendant violates a safety provision? The complaint should list specific examples of the violation of the PFA: dates, times, dates, and descriptions. A hearing will take place in front of a judge who will determine if the PFA was violated and, if so, how the defendant will be punished. The judge can order the following: an extension of the PFA order, a fine up to $1,000, and or up to 6 months in jail. That would all be done after the defendant would be arrested, arraigned, and then a contempt hearing is scheduled. What happens if the defendant violates a non-safety provision? Plaintiff must file a motion for civil contempt with the PFA court to schedule a hearing. At this hearing, plaintiff and defendant will appear before the judge, who will determine whether the defendant has violated a non-safety provision of the PFA order. The defendant is not subject to being arrested, sentenced to jail, or pay a fine. The judge may modify or extend the PFA order as a result of the civil contempt hearing. So once again, these are for non-safety reasons. So they would not be subject to arrest. And sometimes those provisions usually would also be spelled out in your PFA order. Okay, that concludes our presentation. Does anybody have any questions? I could also expand on anything if anybody has any more specific questions related to any provisions in there, or questions about the different types, the emergency, the temporary, or the final.
It looks like we are good on questions, so I'm going to stop recording here. Thank you so much for presenting for us tonight.
Okay, no problem. Thank you so much.